Good afternoon, and welcome to the American Constitution Society Annual Supreme Court Review. I'm Russ Feingold, president of ACS, the country's foremost progressive legal organization with more than 200 student and lawyer chapters across the nation. ACS is celebrating its 20th year of shaping legal debate, nurturing the next generation of lawyers and judges and advocates, and ensuring that the law is a force for improving the lives of all people. We are focusing our work in this anniversary year on our Constitution's founding failures when it comes to race and equity in this country. And concerns about systemic racism in this country must include discussions about voting rights, or more aptly, voter suppression. We are meeting at a critical time, just hours after the Supreme Court issued its decision to uphold voter suppression laws in Arizona. The court's sustained assault on voting rights actually begs the broader question of whether the court now serves more as an impediment to progress in constitutional law than a guardian of them. Of course, you'll hear very interesting comments about this today from our very distinguished panel in a few minutes. The court's decisions this term come in the wake of Justice Coney Barrett's rapid confirmation last fall, while voters were already casting ballots in a presidential election against the backdrop of calls for court reform and the establishment of a presidential commission to examine that very issue. So I'm certainly grateful for today's program, particularly as we grapple with the implications of these latest decisions. This is an important opportunity to delve into these decisions and their impact on constitutional law and racial equity. I appreciate our panel of experts joining us today and lending their insight into this conversation. I also encourage everyone joining us today to check out our new podcast, which we call Broken Law, which will feature an upcoming episode about the latest Supreme Court term. If you don't already, I urge you to follow ACS on social media and online at acslaw.org. There you can find information about upcoming events, our student and lawyer chapters, and priority issues for the progressive legal community, like tracking judicial nominations. It's now my pleasure to introduce our moderator for today's timely discussion, Tom Goldstein. Tom is best known as one of the nation's most experienced Supreme Court practitioners. He has served as counsel to a party in roughly 125 merits cases at the court and recently argued his 45th. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004. He is the co-founder and publisher of SCOTUSblog, a website devoted to comprehensive coverage of the court, which is the only weblog ever to receive the Peabody Award. Tom has received a variety of recognitions for his practice before the Supreme Court and for his appellate advocacy generally. In 2010, the National Law Journal named him as one of the nation's 40 most influential lawyers of the decade. So we are, of course, just delighted to host him again today as the moderator of this annual event. Welcome, Tom.
Thanks so much, Senator. And thanks for your leadership of ACS and for all that ACS does in putting on programs like this around the country and nationally. It's wonderful to get to be with everyone again at the end of a Supreme Court term to try and keep up with all of the developments related to the court and to have such a wonderful program and group of experts that ACS has assembled. It is the beginning of the post-RBG Supreme Court, but not the post-SGB Supreme Court, as we've waited and wondered whether we would hear from Justice Breyer that he was retiring from the court. And of course, there's been no announcement of that sort. And I think it's quite unlikely we'll hear that in the coming days, but it's always a possibility. Our goal here is to go through the major issues of the term that are of interest to ACS's members. And rather than just kind of recounting the facts and the holding of the case, to try and put in context those rulings and show what they mean for how the Supreme Court is evolving and changing for what it teaches us about the membership of the court. We got a number of decisions that show, of course, that we do have a quite solid 6-3 conservative majority, but there were surprises. And the surprises include trying to identify places where there are fissures inside the court, whether it's really 2 blocks or 3 or anything of the sort. And we'll be able to explore those questions through a number of lines of cases. What we're going to do is have each of our experts, after I'll introduce them in turn, go through a particular area of the law, and then we're going to try and reserve roughly 20 minutes or so for everyone's questions. There are, hundreds and hundreds and hundreds of people watching this directly through Zoom, others through the ACS website, others will watch it recorded, and we're grateful to everyone for all of your time and your interest in what's going on with the court. The first person who's going to start us off is Debo Adegbile, who is not just a partner at WilmerHale, one of the country's and world's leading law firms, but also a commissioner on the U.S. Commission on Civil Rights, and is the former legal director and acting director of LDF. And Debo is going to take us straight from Senator Feingold's focus on voting rights to the major voting rights case of the term. Debo?
Great. Thanks, Tommy. I appreciate it. And it's great to be here with the ACS audience today and with Senator Feingold and all of the other panelists. So today is another big day in voting jurisprudence in the United States. We had the court's ruling in Brnovich, which we were waiting for. We expected that it would come at the end of the term, as blockbuster voting cases tend to. And we were not disappointed in that expectation, though. Those of us who care about minority voter participation and access to the polls were certainly disappointed in the ruling. I think I may begin by talking a little bit about what the case was about, why it's important, and then speak a little bit about some of the broader issues that Tommy set out for us, including what it says about the Roberts Court, what did the court do today with this decision, and what does it tell us about where we are in our democracy. So what was the case about? And in the first instance, we have to think about this case coming just 8 years after the blockbuster case in Shelby County. The Shelby County case took away what was one of the most important pieces of the Voting Rights Act, something that I regarded as the heart of the Voting Rights Act, the pre-clearance provisions of the Voting Rights Act, which helped minority voters block or deter voting discrimination in some of the parts of the country that had the most entrenched histories of voting discrimination. And the Supreme Court in Shelby County essentially took the pre-clearance provisions off the table. And that was just 8 years ago last week. What we were left with after that provision was taken away was the broader Section 2 piece of the Voting Rights Act, which applies nationwide. It's noteworthy to know that one of the arguments that plaintiffs advanced in Shelby County in urging the court to strike down the pre-clearance provisions was that the Section 2 nationwide provision stood as another tool and was adequate to combat minority voting discrimination nationwide. And so today we come to this case, which raised the question about whether or not 2 particular types of voting measures and election measures impede minority voters' access to the polls. One of the provisions at issue was something that I like to think of as a practical matter, as a piece of like voter roulette. This is the piece about whether or not you are voting in the proper precinct, the precinct that you have been designated to vote in. And if you vote in the wrong precinct, if you show up at a polling place and vote in the wrong precinct, your whole ballot is disqualified. Not just your ballot for whatever local race may be applicable to that precinct, but more broadly, your vote for president, your vote for senator, your vote for your congressperson. I want folks to just understand one fact here because it's very important. Very often in polling places, there are multiple precincts that people vote in a single room. So for example, in a single gymnasium, people can be voting in all sorts of precincts, and all of you or many of you will remember that you often get directed to vote at one table or to walk across the gym and the foul line and vote at another table. This provision being attacked in this case was one that could disqualify a voter's ballot if they walked to the wrong table in the right room. And that was what part of this challenge was about. The other piece is equally, I think, ridiculous, but in some ways even more shocking. It was the criminalization of assisting voters who are trying to cast an absentee ballot. Many folks are not able to get to the polls. Many folks are homebound or have difficulty with transportation and other things. And some folks live in remote parts of the country where it's hard to get to the polls. And so one way to enable that everybody's voice is heard is to help people get their ballots in and have their ballots delivered so they can be counted. One of the provisions being challenged in Arizona was a provision that doesn't just forbid people from assisting, a specific group of people from assisting, but it criminalizes the act of trying to assist somebody to vote. It criminalizes it, makes it a felony that's punishable by 2 years in jail and a $150,000 fine. The motivation for these provision, or this provision in particular, was concerns about fraud or intimidation or manipulation of voters' will. And the underlying case here was challenging these two provisions under Section 2 of the Voting Rights Act, saying that they had a disproportionate effect on minority voters. For example, that voter roulette provision that I spoke of, twice as many minority voters had their votes disqualified under that provision than white voters. But the Supreme Court in today's decision essentially reversed the en banc panel of the Ninth Circuit and held that it was not a violation of Section 2 of the Voting Rights Act to have that provision in place. They found that the level of disparity was not substantial enough to constitute a burden that's cognizable under Section 2. And many of us were sort of looking for a standard in this case, a clearly articulated standard of what type of analysis courts are looking to do when you're faced with provisions that deny or abridge, deny or shorten or narrow the right to the polls. And the court didn't settle upon a clear standard, perhaps because they couldn't forge an understanding about what that would be. But Alito, in his opinion, pointed to several guideposts of things that you should consider in these Section 2 cases. And each of them, separately and together, give what I would submit is a very cramped reading of what the utility of Section 2 will be in the future. And so this case is important because it's another blow to the Voting Rights Act as being a powerful tool to respond to minority voter discrimination. It imposes a cramped standard, which, for example, in the court's opinion, looks back to the type of access and the levels of access that were in place at the time of the 1982 reauthorization, when Section 2, the language of Section 2 was amended. In that way, it sort of locks in time a conception of voting discrimination to a period when voting discrimination was still so urgent and pressing in the United States that Congress decided we needed 25 more years of robust Voting Rights Act protections. And the idea that we would lock it in that way and have to look to the 1982 conception of what access to democracy looked like is also inconsistent with our experience. Because the one thing that we know in voting is that voting discrimination is both persistent and adaptive. That is to say, there are pieces that are continuous and pieces that fade away. And so what does this mean? What does it tell us about the Roberts Court? It tells us a couple of things. We know more clearly now than ever before that there are two ways to win elections. You can win through mobilization and getting your people out and persuading them with your policy prescriptions and getting people excited to come out to the polls, registering more people. Or you can win by narrowing and demobilizing and trying to block voters that are weighing in for your adversary. Both of these are long traditions in the United States in American elections, and both of them can prove successful. What we have when you read these cases together is that we have, in effect, a series of safe harbors for those who would use the notion of winning elections through subtraction and by imposing obstacles, as opposed to a more robust notion of the Voting Rights Act that leans into the minority inclusion principle that the Voting Rights Act stands for, that leans into a more narrow and cramped idea, which creates spaces for obstacles that will be harder to challenge in the future. There is no voting rights litigator that will tell you that today's decision will not make it harder to use Section 2 as a tool to interrupt voting discrimination and disparities that we see in electoral processes. And as I said, we have to read these cases together. I'll close with this notion. One measure of a court is to think about where it is on these issues of democracy and inclusion. We look back to the Reconstruction Court. In a sense, we have the Voting Rights Act itself, in part because of a judicial dereliction in validating and giving voice and protection and serving the guardian role that Senator Feingold spoke of. We needed Congress to come forward with powerful medicine to lean on the side of inclusion and the minority inclusion principle. Read together, the Shelby County case, certainly the photo ID case of years ago, and today the Brnovich case will likely cause historians to determine that this court, the Roberts Court, was on the side of creating space for states and localities to impose barriers to voting that leads us to a path of democracy's low road, trying to have elections be characterized by allowing the conception of winning by subtraction, as opposed to the more robust and vital democratic notion of winning elections through addition. And it's an ahistoric ruling that will not stand the test of time. And it's my great hope that Congress will come forward and meet this decision in a way that is constructive.
So Debo, I have two questions for you, if you wouldn't mind. The first is, there was a lot of concern that Justice Alito, in an opinion for the court, would call into question the constitutionality of Section 2 of the Voting Rights Act. And so if you could talk for a second about what happened there. And then just to pick a particular example, the Biden administration has, of course, filed suit against Georgia with respect to a series presidential election. And I wonder what you think, without trying to predict the outcome, what the implications are of today's ruling on the Section 2 claims that could be brought in Georgia.
Absolutely. So taking them in order, Tommy, I guess with respect to the first one, it's interesting to note, and folks can go back and look at this. I believe Chief Justice Roberts was asked in his confirmation hearing about the constitutionality of Section 2. And he gave what came close to an answer. Very often, justices don't give answers when they're asked about questions that come before them. But he seemed to suggest, in ways that were a little surprising to advocates at the time, that he did not have a strong sentiment that there were constitutional questions about Section 2. Of course, that doesn't bind anybody. It doesn't bind the chief. And as you've already noted, the majority of the court has shifted in a way that may not be determinative of the future of Section 2. Part of what we've seen, however, is that the court sometimes in this mission to sort of lead in the direction of what I consider democracy contraction rather than democracy expansion, does so incrementally. That is to say, we had the Northwest Austin case, which sounded a warning about the preclearance provision before we had the Shelby County case, which ultimately took it off the table. And there is a sense in which, for various reasons, sometimes the court likes to move slowly. There's not a clear suggestion in this case, though there are multiple opinions. There's not a clear suggestion that Section 2 ultimately will be called into question. But at a moment when Congress is very focused on the response to the last momentous Supreme Court decision, it would not surprise me that the court was thinking that throwing gas on the fire of this rattling about the security of our democracy and the threats to it might not be where the court wanted to be at this moment. So that's how I think of that question and with respect to the constitutionality. Today's not a final answer, but there's some indications that maybe that is not coming. The other thing is that when you shrink it so much and you make it such a limited provision, there may be less need, right, that to ultimately strike it down. So I guess that's another consideration. On the broader question about the way in which DOJ is proceeding, the Department of Justice did not weigh in. They did not argue in this case. The Trump administration had filed a brief in support of the ruling that was essentially trying to protect these provisions that I have described. And there was an opportunity, I think, not a big opportunity because of the timing of the calendar, but there was an opportunity for the Justice Department to reverse position, as it has done in some other cases that are pending. And instead, it sent a narrow letter, essentially blaming the lack of time, but suggesting that the new administration did not subscribe to the interpretation of the previous administration, but without briefing and certainly without a request for time. What was noteworthy in the Attorney General's announcement was that he was focused on the purpose of the Georgia enactments. That is to say, it was almost as if that press conference was offered and framed, and the filing was offered and framed with some anticipation that there could be a decision coming that would narrow the effect and the results test that exists in Section 2. Today's ruling was in part about that piece of Section 2. Discrimination that results in a lesser opportunity for minority voters to participate in elections. And I think DOJ was anticipating a narrowing ruling, and for that reason was framing their concern as more of a purpose, an intent-based concern at narrowing the path for minority voters. So I think this will still play out. Doesn't mean that you can't bring a results case. It does mean that the law in this area is not finally settled, because the court had an opportunity to announce a clear standard, and instead what we got were guideposts.
Okay, well, thanks so much. So let's turn now to criminal law. Rachel Barkow is at the NYU School of Law, as one of the country's very leading academic scholars with respect to criminal law, is the faculty director of the program that they have on the administration of criminal law, and is going to talk about both an Eighth Amendment and Fourth Amendment case.
Great, thanks, Tom. So I'm going to highlight those two cases and kind of flag one more on retroactivity, just so folks are aware of it. But I'm going to start off by talking about the Eighth Amendment case, which is Jones versus Mississippi. And this is a case that builds on two prior cases that the court had decided, Miller versus Alabama and Montgomery versus Louisiana, which were cases that asked when a juvenile could get a life without parole sentence for a homicide. And in Miller, the court said it can never be mandatory. And in Montgomery, the court said that Miller holding had to apply retroactively. So if somebody had been given a mandatory life without parole sentence, they were entitled to retroactive relief. And the question in Jones is, what did it actually look like when you got that new hearing? And in particular, Jones, who had committed a homicide, had killed his grandfather when he was 15 years old, when he got his new sentencing hearing, the judge gave him life without parole again. And Jones had argued that the judge could not do that, consistent with Miller and Montgomery, unless the judge first found that he was permanently incorrigible, that you had to find that, there was kind of no hope for development, either on the record finding or an implicit finding in that regard. So the Supreme Court rejects the claim. It's 6-3. And Justice Kavanaugh writes for the court. He writes for all the conservative justices except for Justice Thomas, who I'll get to in a minute. And in the Kavanaugh opinion, the big hurdle is how on earth can you have that ruling given what Montgomery said? Because Montgomery said Miller was retroactive, which means that Miller had to have been, it was a substantive decision, not a procedural one. It wasn't just about getting a new hearing, because in order for the court to find that it's retroactively available, it would have had to have been substantive, because in a case I'm going to get to in a minute, the court clarified this term: you cannot get retroactive application of a criminal justice ruling from the court if it's just a procedural rule. It used to be a little narrow opening that said maybe if it was a watershed rule, and the court ditches that this term. So Montgomery says it's substantive, and the substance of that rule is you cannot get a life without parole sentence as a juvenile unless a court finds that you're permanently incorrigible, because otherwise it's an Eighth Amendment violation. It's cruel and unusual. So how does the court square that? Well, the court has to deal with this language. Let me start with that, because I actually thought this was a pretty reprehensible decision by the court and not just explicitly saying they're rejecting Montgomery. And the reason I say that is because Montgomery said, and now I'm going to quote here, that all juvenile offenders, except for a rare few whose crimes reflect permanent incorrigibility, are categorically exempt from life without parole. Even if a court considers a child's age before sentencing him or her to a lifetime in prison, that sentence still violates the Eighth Amendment for a child whose crime reflects unfortunate yet transient immaturity. All right, so how did the majority deal with this? Well, first they say, there were vigorous dissents in Miller and Montgomery. Okay, and then they say in a footnote that Montgomery's decision that Miller was substantive is in tension with the court's retroactivity precedents, but we're not overruling it in the sense that we're saying Miller still applies retroactively, but it's applying it retroactively in a way that essentially makes it meaningless. So now we get to Justice Thomas's concurrence, where he says, come on, guys, we have to be honest here and just say Montgomery shouldn't have made Miller retroactive. It was a demonstrably erroneous decision and it should be overruled. And he says, Montgomery's creation of a categorical exemption leaves us with two options. First, we could follow Montgomery's logic and hold that the legality of Jones's sentence turns on whether his crime reflects permanent incorrigibility, or we could acknowledge Montgomery had no basis in the law. And then Justice Thomas says, but the court selects a third way: overrule Montgomery in substance, but not in name. All right, so the dissent takes the majority to task for this as well, and just reminds us what's at stake here, because in states like Mississippi and Louisiana, where the judges haven't had to make that finding, in Mississippi, 25% of the kids are sentenced to life without parole again. In Louisiana, it's 57%, and it's mostly people of color. 70% of the people who get LWOP sentences in America are they're kids of color. So here I just want to highlight, usually we call these like stealth overrules, but this is like the worst stealth overrule ever, because everybody saw it and the court just won't plead to the fact that it's doing it. So that was, I thought, really disappointing, both on the merits, but also just in the intellectual dishonesty of what they were doing. Second case that I want to just quickly flag is, as I mentioned, there's a case called Edwards versus Vinoy that was decided this term, which is about this retroactive application of criminal procedure rules. That was a decision where the court was trying to decide whether or not its decision in Ramos, previously finding that a non-unanimous jury violated the Constitution, whether that applied retroactively. Court says no. And in saying no, says, look, this is a procedural decision. And so under Teague, we'd have to ask, is it a watershed rule? And the court says, we have never found one of those. We didn't say it in Mapp, Miranda, Duncan versus Louisiana, Crawford. And so the court says, how can we say this one qualifies, or any case qualifies? And says, in fact, the only candid answer is none can. And so the court says, we're just going to get rid of the fiction that there's a procedural prong anymore. You only get retroactivity if it's a substantive rule. And I just want to flag this case for you, because if you're familiar with Justice Kennedy's jurisprudence, he did this a lot. He'd have a kind of, not this case, not actually any case I've ever seen, but someday, sometime, maybe, I want to leave the door open for the hallmark of his jurisprudence. And I think it's interesting that the court found in this case that it was good to play cleanup and just say, it was just false hope for people. And we're going to just own up to the fact it was never really available and get rid of it. And the reason I think this is important, in particular in criminal justice cases, is because that was Justice Kennedy's approach to the Eighth Amendment and unusual, but never found one to be the case. It's a test that's pretty unforgiving, but it kind of holds out hope. And I'll be curious to see whether they say anything more about that using this kind of metric of, but we've never found anything to violate it. So then the last case that I want to highlight for you, as Tom mentioned, is a Fourth Amendment case, Torres versus Madrid. This is a 5-3 decision because Justice Barrett didn't participate in this one, but it's, the 5 traditional conservatives in the majority and the 3 more liberal judges, I'm sorry, excuse me, it's Justice Roberts and Kennedy with the 3 liberals in the majority, and Justice Gorsuch, Alito, and Thomas in dissent on this one. So this case holds it's a seizure when the police shoot at a suspect, hit the suspect while the suspect is fleeing, even if they don't catch them. Now, you might have thought, if you're a criminal procedure type, didn't the court already decide this in Hodari D? Because Hodari D was an opinion by Justice Scalia that said the word seizure readily bears the meaning of a laying on the hands or application of physical force, even when it's ultimately unsuccessful. And the majority says, yeah, we agree with that in Hodari D, but even if we didn't think that was binding on us because it's dicta, we independently think that's right, looking at the common law cases. The dissent by Justice Gorsuch, it's 26 pages, saying that can't be what a seizure means. That doesn't seem textually right, and there's no clear-cut case from the common law on point. And Hodari D, even though Justice Scalia might have said that in dicta, he didn't get a chance to carefully consider it. Had he done what we just did, which is comb through every common law case on earth, he would have found it doesn't apply. So this one, to be perfectly honest with you, because just saying this is a seizure doesn't really get a litigant much of anything. The next step would be showing it was an unreasonable one. In a civil suit like this one, they'd have to get past qualified immunity. What I think is more significant about this case is it looks to me like it's setting a methodological precedent. This court really cares about how the common law treated things like arrests, seizures for Fourth Amendment purposes. And that's going to be odd because 18th century policing doesn't look like policing today. And just to give you a little taste for what I'm talking about, the court says the closest decision on point in deciding this one was the Countess of Rutland's case. And in that case, the sergeants at Mace had tracked down Isabel Holcroft, the Countess of Rutland, to execute a judgment of debt. And in that case, the quote is, they showed her their mace and touched her body with it, said to her, "We arrest you, madam." So that's what's guiding our Fourth Amendment jurisprudence from here on out. It means you'll have to find your common law analog to things that look very different than, say, a police shooting at a car that's running away. And then the view that I have noticed this term, and in these cases in particular, is the importance of a Justice Scalia opinion has taken on a kind of life of its own. It's sort of like if you read cases where someone mentions, oh, that was an opinion written by Judge Friendly. You know, they have to let you know it's a Friendly opinion, or back in the day, maybe a Posner opinion. There were certain judges that kind of got that hallmark treatment. And I think that's what's happening with Justice Scalia now. They spend a lot of time trying to figure out what he said, what he did, or is what they're doing consistent with what he said. And I suspect we're going to see a lot more of that going forward.
Thanks so much.
Tommy, can I ask Rachel something about that?
Oh, please.
You know, what do you make of the note in that last case that even the Scalia opinion was criticized as not having been thorough enough to fully apprehend the applicable jurisprudence?
Yeah, I mean, I thought it was Justice Gorsuch's way of saying, look, I'm still a faithful Scalia adherent, but it was dicta. I don't think he looked closely at this and, wouldn't have agreed to me. So, I will never know what he would have thought of the Countess of Rutland's case. But if I had to take a guess, I think he might have found the majority's opinion here pretty persuasive. But the whole enterprise, if you think about it in terms of forest for the trees, the kind of amazing thing about that is we really were talking about these, 18th century debt collection cases, as opposed to thinking about police use of force in an environment in our current times that looks so very different. And the court mentions none of that.
Tremendous. So let's turn to the First Amendment. Sarah Harris, who's a partner at the Williams and Connolly firm, has argued multiple cases successfully at the Supreme Court, and is going to take us through the two principal speech cases at the court.
Thanks so much, ACS. Thanks, Tommy, for the nice intro. And thanks for having sort of a range of diverse viewpoints, which I think is a particularly fun way to discuss the Supreme Court this term. So big term for the First Amendment, I'll discuss Americans for Prosperity, which came down this morning first, and then the Monoy cheerleader case second. So Americans for Prosperity, there's a California law that requires charities operating in California to provide a list of their confidential donors to California, which California says they will use it for the purpose of rooting out charitable fraud. Everyone agrees, bad, and will keep the list confidential. That point is debated. The question is, does the First Amendment prohibit that disclosure mandate? And today, in a 6-3 decision reflecting an ideological lineup, the chief writing for the court says, yes, the California regulation is indeed facially unconstitutional. A majority agrees that at a minimum, the test for evaluating compelled disclosures is exacting scrutiny. Now, you might ask yourself, what the heck is exacting scrutiny? Sounds like mushy tiers of scrutiny language. You would not be totally wrong in that question, because much of the briefing debates, what the heck does that mean? Is it really more like strict scrutiny? Is it some other kind of scrutiny? The court says, it turns out it's kind of like a combination of some other forms of scrutiny plus a little bit of strict scrutiny. And it means that you need the disclosure regime to be narrowly tailored to the government's asserted interest. But unlike strict scrutiny, you do not necessarily need to show that the government had the least restrictive alternative that they picked. So it's just, something a little less than strict scrutiny, something a little more than other scrutiny. And the court agrees on the bottom line, and 6 justices all agree, saying at a minimum, if it's exacting scrutiny, California's law is going down facially, because even accepting that California has a substantial interest in policing charitable fraud, the problem is, the court says, there's too much of a mismatch between that interest and the range of donor information that California wanted to obtain, which is a lot of information that the court deemed sort of peripheral to California's needs when policing charitable fraud. So why should we care about this? A couple of reasons. One is just sort of from a nerd perspective, it illustrates actually a divide among conservatives. I think you look at it and see 6-3 conservatives and liberals. But the interesting thing about this opinion is how it breaks down. The court leaves open whether exacting scrutiny or strict scrutiny is going to apply going forward, because basically there's a majority of justices for the proposition that's at least exacting scrutiny. 3, the chief, Kavanaugh, and Justice Barrett would just do exacting scrutiny. And then 3, sort of further on the right, would go further. Alito and Justice Gorsuch joining concurrence together. They say, not going to decide today whether it's exacting scrutiny or strict scrutiny. And then Justice Thomas, just writing for himself, says strict scrutiny 100% of the time in all compelled disclosure cases. So that sounds kind of technical, because a lot of the tiers of scrutiny language sounds frankly made up. But it does matter in terms of exactly how hard of a line the court is going to take in terms of, can these compelled disclosure regimes of donors survive? I think it could matter in other cases, obviously not in this one. What else does it show? I mean, I think while it shows that there's this dynamic going on sometimes with 3 conservatives wanting to go further than the other 3, overall, this case actually also, I think, illustrates that the court in the long run has actually come around to Justice Thomas's view. For a long time, Justice Thomas was the only justice who really saw a close connection between the right to associate, the freedom of association, and compelled disclosure regimes that require people to disclose who they're associating with. And today, I think 6 justices really buy into that concept. That's a big change in the law if you look throughout like kind of the last 20 years of this. What else is interesting, I think, looking at the term as a whole, this is one of the few big cases where people were following it all term as a big case. It turned out to be big. There are a lot of other high-profile cases that end up kind of fizzling in terms of having a sort of sweeping holding on the merits. Fulton is one good example. That's the Catholic Charities case that we'll hear about soon. And then obviously the Obamacare decision, a lot of writing devoted to will this be the year that the Affordable Care Act goes down? Answer, no, definitely not. Really sort of a very minimal holding on standing by Justice Breyer. But this case is notable because unlike the other cases where the court kind of chose off-ramps to go narrow, the court could have done that in this case. There was a pretty, the challengers made as applied challenges based on really trial records. The court could have just said, in your 2 cases, you have shown that there is sort of a chilling effect on your speech. So we are going to invalidate the regulations as applied to you, but we're going to leave open whether other people need to amass a similar record. The court instead said, no, the law is facially invalid. Even if some people don't mind disclosure, and even if the data isn't publicly disclosed, there's just a mismatch between the state's interest and what they're using this information for, and so the law can't stand. What else? I mean, this is one of the few big cases that was actually on ideological lines. I think one of the big trends of the term is that there are 10 argued cases that were 6-3s. 6 reflect an ideological divide, but 3 of those 6 were sort of criminal law cases or immigration, where the court just often splits on ideological lines, regardless of how big or small the case is. And the sort of big 3, I think, that do reflect sort of more of an ideological divide are this case, Cedar Point, which is a takings case, and Brnovich, obviously the voting rights case. And even of those cases, I mean, I think one remarkable thing is it's harder to classify Americans for Prosperity as sort of a partisan case. I know there's a lot of press reports saying this is cases about sort of dark money in politics, et cetera, et cetera. But I do think it's notable. I mean, if you look at the amicus briefs in support of the challengers, you have like people who are not necessarily associated with like, you know, right-wing causes like the ACLU or the NAACP. I mean, they're associated with the proposition that donors should be confidential because people across the ideological spectrum may be harassed or intimidated if their donor rules are disclosed. And that does seem like a fairly non-ideological position. Final thing on this one is the practical consequences could be pretty significant. The dissent says the decision sort of puts a bullseye on all sorts of reporting and disclosure requirements, and that might be right. It's certainly going to embolden a lot of challenges. The ones to watch out for next are campaign finance, and also sort of the extent to which the IRS can go forward and kind of try to crack down on, you know, looking at nonprofit exemptions. And so that brings me to the second big First Amendment case, Monoy, where the question was whether schools can regulate off-campus speech under the standard of Tinker versus Des Moines Independent Area School District, or i.e. can schools regulate off-campus speech that would cause a substantial disruption on campus? Third Circuit below said no. The Supreme Court, in an opinion by Justice Breyer, says yes, schools can regulate off-campus speech for all sorts of pedagogical reasons, at least sometimes, including for on-campus disruptions. But this court says on the facts of this particular case, you cannot regulate the speech of the so-called cussing cheerleader. And so there's an 8-1 ruling in the student's favor. And the speech here, you may have seen, it's been very well publicized, involved a cheerleader who sent snaps expressing her dismay about the outcome of the varsity cheerleading competition. And one snap features a sort of almost haiku-like litany of F words: F school, F softball, F cheer, F everything. And the court sort of says this speech is just not disruptive enough on the record for the school to punish. Leaves open whether a different record might have even had a different result here, but says F this one. So the ACLU is now selling to dismiss it on t-shirts, which is a perfect gift for that special someone in your life who is looking for a pairing with our Cohen versus California F the draft jacket. What else is interesting about a few observations? One is it's a rare case where the court made both sides happy, which does not happen a lot of the time. The ACLU obviously very happy to win, I suspect, on the judgment line. Their client obviously vindicated in the principle that the school did not have the authority to discipline her for her off-campus speech about cheerleading. They also obtained good language in support of student speech going forward with respect to envisioning some sort of balancing for off-campus speech, sort of saying you really can't, schools really cannot engage in a lot of regulation of off-campus speech. They need pretty convincing pedagogical reasons. And it's different from being on campus. But the school district also got a lot, really vindicated, I think, on the proposition that schools care about, which is schools can indeed regulate off-campus bullying, off-campus harassment, off-campus threats that are the cornerstone of most of the other cases that had come up in this space. And so the Supreme Court's ruling actually kind of keeps intact results that every other circuit, except for the Third Circuit, had sort of endorsed up until this case. Second of all, I do think this is a pretty big First Amendment case. I mean, in the previous cases in this area, the court had been pretty narrow in talking about, say, like speech about drug use or cabinet news, like speech about vulgarity at school assemblies. But in this case, the court just looks like it's trying to start getting together and creating sort of a framework going forward for different pedagogical interests. And I think that is important. It's a very sort of briary balancing test. And then third, in a similar vein, I think it exemplifies a big theme of the term, which is a really huge term for Justice Breyer. And I think that reflects the fact that in a term where the court is a bit fractured, pragmatists are king, and he is sort of one of the kings of pragmatism. time, I think he does well attracting votes when he can have a multi-factor approach that different justices like different factors of them. And he got a lot of big opinions this term besides Monoy. He also had Google, big win for Tommy, obviously, but also for the future of software development in Silicon Valley. Very practical approach there. AMG constraining the FTC's enforcement powers, and also the Obamacare decision. So I'll end there, but I'll just say one final way to view this decision. Just to sum up, the Breyer majority is sort of F the Third Circuit. Justice Alito's concurrence is F viewpoint discrimination. He feels very strongly about that. Justice Thomas had a dissent, which was sort of the F modern precedent. But I would say 3 cheers for the First Amendment, and the school and the justices are out for the summer.
Thanks so much, Sarah. Let's turn to Elizabeth Sepper, who's one of the country's leading scholars with respect to religion issues. And we had, of course, the Fulton case, which has been mentioned in passing, and then a body of cases about the intersection of COVID regulation and religious liberty, and changes with respect to free exercise and establishment law are probably among the most important we could see coming from the court in the next several years. So, Elizabeth.
Thank you, and thank you for having me, and for all of you who are out there in the web world. It was a very busy term on law and religion issues at the Supreme Court, and this has become a norm in recent years, where we see lots of decisions and some major shifts. Arguably, maybe we saw fewer major shifts this year, fewer than we expected, certainly. We saw 2 basic phenomena. First, we saw a series of decisions on the court's shadow docket addressing religious objections to regulations aimed at the pandemic. And the court decided a few weeks ago, Fulton v. City of Philadelphia, a case pitting against non-discrimination requirements contained in its contract with the government. Now, religious organizations brought dozens of lawsuits under the Free Exercise Clause challenging state and local efforts to control the spread of COVID-19. And during the initial months of the pandemic, courts turned these away. There's an overwhelming governmental interest against mass gatherings for any purpose, including worship. These requirements applied, the court said, generally. But then at Thanksgiving, we got Roman Catholic Diocese, and here we saw Justice Barrett's appointment make its first major impact. So the court swung from upholding public health measures 5-4 to enjoining them 5-4. Before then, as my colleague Steve Vladeck at Texas has documented, it had been 5 years since the Supreme Court had issued an emergency injunction. Since Roman Catholic Diocese, the court has continued to enjoin state and local public health measures in favor of houses of worship primarily. Now, there were a number of these cases. They culminated in a case called Tandon v. Newsom at the end of April. So under our 1990 standard for looking at free exercise objections in Employment Division v. Smith, the court had held that religious objectors are not entitled to exemptions from neutral and generally applicable laws. And the court therefore granted religious exemptions only where it saw discrimination against religion, where the law was not neutral in some way. In Tandon, the court instead held that any secular exemption to a law automatically creates a claim for a religious exemption and subjects the law to strict scrutiny. So California there had a blanket rule against in-home gatherings of more than 3 households. This affected secular gatherings, but it also affected plaintiffs' ability to hold larger in-home Bible study groups. But the court didn't look at secular in-home gatherings as compared to religious in-home gatherings. Instead, it said by allowing grocery stores and other businesses to hold more than 3 households at a time, the state had created, quote, a comparable secular activity, had treated a comparable secular activity more favorably than religious exercise. So this is what's known as the most favored nation theory, which basically means if you have 2 activities, if you can make the claim that the secular activity is like the religious activity and the secular activity isn't covered by the law, then a religious exemption should be granted. So here, since both Bible study and grocery stores present some risk to the government's interest in reducing COVID transmission, the court treated them as comparable and found failure to regulate them equally could not stand. Now, there are big picture questions about whether the court made new law. It was a per curiam opinion. It was unsigned, although Fulton strongly suggests, I think, that Justice Gorsuch was the author. And it only gave us 4 pages to go on. By my take, it is a new rule. It may be a rule that will take off. It's not contradicted by Fulton in any case. But again, we only have 4 pages to go on. So then we got Fulton, and Fulton, as Sarah said, could have been and was expected to be a big blockbuster. It was less than a blockbuster, at least we have that much, but it contained a number of surprises. So this particular case revolved around a contract between the city of Philadelphia and Catholic Social Services, where Catholic Social Services would certify families for the city's foster care system. CSS had agreed to the city's non-discrimination policy in its contract, but then it proved unwilling to certify some LGBTQ families based on its religious beliefs. So the city terminated this particular contract, and then the agency claimed it was entitled to continue as a contractor under the Free Exercise Clause. And they asked the court here to explicitly reverse Smith. That's not what happened, and that was a surprise, right? In some ways it was foreshadowed by oral argument, but I don't think we saw this particular result coming. What happened here was that Chief Justice Roberts, in what Justice Gorsuch, I think, rightly calls a dizzying series of maneuvers, essentially reinterpreted the city contract and the city anti-discrimination law to say that there had been a formal system of individualized exemptions, which under Smith gives rise to strict scrutiny. If you're willing to exempt on a discretionary basis particular agencies, why not the religious agency? It's not really what happened here, but this series of maneuvers suggested that's how the contract worked. And then, of course, CSS was granted an exemption because strict scrutiny made short work of the contract. The second surprise was that the justices unanimously agreed. There was not one dissent published. I think this matters quite a bit. I think it was an enormous mistake by the more liberal flank of the court. I think they give the impression that this result and the reasons used to justify it have support that they actually lack. And they're handing their conservative colleagues and my conservative colleagues a powerful rhetorical weapon. They will say, as they did with Hosanna Tabor, the court was unanimous. Anyone who would disagree obviously must have hostility toward religion or an ideological blind spot. Now, I want to suggest that Fulton may not be as narrow as it first appears. The immediate effect is that agencies in Philadelphia, I think, can demand all sorts of exemptions that they couldn't have before. And it may have ripple effects, right? Not all contracts will contain provisions that suggest an individualized exemption process, but many do. And the federal government can typically grant waivers that may be turned into an individualized discretionary exemption process. Ultimately, in terms of big picture takeaways, I think the court continues to see discrimination against certain religions, while notably overlooking discrimination against others, as in the Muslim ban case. It continues to be inclined to bend the existing Smith rule in favor of certain religious entities. And the most favored nation approach adopted in Tannen offers one possibility by which the court could continue to evade Smith whenever it suits the court, but only whenever it suits the court. Just find a secular exemption and argue the particular religious activity must be treated in the same way. So Smith still seems on shaky ground, but Fulton does reveal some possible splits between the justices inclined to overrule it. And Justice Barrett gave us an explicit statement for the first time, indicating both her willingness to reverse Smith and her skepticism of a one-size-fits-all strict scrutiny approach to religious objections. So we may just have the new lemon test. Maybe Smith is the new lemon. Lemon is an establishment clause test that the Supreme Court has never explicitly overruled in its entirety because of disagreements between justices, but that is basically defunct. But I suspect, as Justice Alito predicts, we'll see a lot more of these cases. And the court currently has 2 petitions for cert that raise issues around LGBT equality and religion. Thank you.
Thanks so much. So what do you think, Elizabeth, about the prospects for Smith? You know, what is it that we should be looking for? Do you think it's interred, so the point that the rubber finally has to hit the road and that we can't reconstrue a contract or a municipal ordinance, they finally will overturn it? Or do you think there is the real prospect of the Smith rule surviving? And how does this relate to the earlier point that, you know, there's a special place in the pantheon for Justice Scalia opinions given his relationship with Smith?
I would say there's no special place for Scalia's Smith opinion in his pantheon. So I don't think that we would see the sort of back and forth between Justice Alito and Justice Barrett over what would Scalia do here with regard to Smith, because they both really reject Smith as a rule. So I think it's likely that Smith will eventually be explicitly overruled, though perhaps not in the way Justice Alito would prefer. But in the meantime, I think what we've seen the court do is simply stretch Smith until it's meaningless, and do so in a way that favors particular religions, and I think to favor powerful religious entities. And that almost makes me think maybe that's what the court will prefer. If Smith were genuinely overruled, right, lots of different minority groups with lots of different, but if the standing really, if the claim from a religious group depends on whether the Supreme Court sees you as suffering discrimination, or conservative justices see you as suffering discrimination, that's going to favor certain religious entities over others. And going ahead with the most favored nation approach, or with the current, we see discrimination in various places, especially against conservative Christians, I think we may end up in that place, at least for a while still.
All right, thanks so much. Let's turn to our final panelist, who's Pratik Shah, who is the head of the Supreme Court and Appellate Practice at the Akin Gump firm, has argued and prevailed in more than a dozen cases at the Supreme Court, and is going to talk about 2 major, although pretty distinct, decisions this term involving the Affordable Care Act and also international human rights.
Thanks, Tom, and it's a privilege to be with ACS today, whose work I think is maybe now more important than ever, as we've seen the steady rightward march of the court, where I think really the only question is how far and how fast over the years to come. But do not despair. There are some arguments that are so bad that even this court will reject. And that brings us to the Affordable Care Act case, the California v. Texas case. And if you're getting that deja vu feeling again, you can understand why. This is the 8th ACA case to reach the court, and the 3rd major one, yet another attempt to knock out the Affordable Care Act. This one started with Congress's single amendment to the Affordable Care Act a few years back that zeroed out that tax penalty. And if you remember from the Chief Justice's famous NFIB opinion, there was a tax penalty that if you don't comply with the so-called individual mandate that the Affordable Care Act requires you to obtain insurance coverage, then you pay a tax penalty. So what Congress did is it just went to that dollar amount and made it zero. It did not touch the rest of the 900 plus pages of the Affordable Care Act. Texas, however, sues, joined by a bunch of red states and a couple individuals. It sues and says the Affordable Care Act is now, this individual mandate provision in particular, is now unconstitutional. The Trump Department of Justice, in varying degrees over time, went defending to defending in part to not defending the statute at all. So basically joined in Texas's challenge. California, however, came into the suit along with a bunch of blue states to defend the Affordable Care Act, as did eventually the House of Representatives once it was up to the Democrats. They also intervened. The district court, this was in Northern District of Texas, ruled in favor of Texas, and it said, this is no longer a tax. The tax penalty is zero. You can't use the taxing power as the Chief Justice had done in NFIB, so the individual mandate is unconstitutional. But you might ask, who really cares if the tax penalty was zeroed out anyways? The individual mandate really isn't doing any work. Well, the reason everyone cared is because Texas said, once you invalidate the individual mandate as unconstitutional, the entire rest of the Affordable Care Act, all 900 plus pages, must fall as well because it is inseparable. That is, they rise and fall. Congress would not have wanted the rest of it without the individual mandate. The district court agrees, strikes down the entire Affordable Care Act, which is stayed pending Fifth Circuit review. A divided panel of the Fifth Circuit affirms on the individual mandate, says that's not constitutional, but sends it back to the district court, vacates and says, you need to show your work on severability before you strike this thing down. But the Supreme Court then jumps in before it gets back to the district court. There were three issues on which the Supreme Court granted cert. The first issue is the threshold issue of standing. Do these plaintiffs, that is the Texas-led states, and or the individual plaintiffs who joined, have standing to sue? That is, are they injured by this individual mandate provision? Second issue is the merits. Actually, is the individual mandate constitutional if it's no longer supported by the taxing power, even if it really does nothing? And then the third issue is severability. That is, should the rest of the Affordable Care Act fall with the individual mandate if it, in fact, is unconstitutional? The oral argument, as you might expect, was all over the map, given these three issues and given the various positions of the justices. I'll say with one exception, severability. There, the Chief Justice and Justice Kavanaugh sort of laid their cards out on the table. We already kind of knew where the three more liberal justices would be. They would never hold the Affordable Care Act to be inseverable, that all of these unrelated provisions should be struck down as well. But the Chief Justice and Justice Kavanaugh made clear that they would join those three liberals if that issue came up. The Chief Justice said, quote, "It's not our job to strike down the rest of the Affordable Care Act." And Justice Kavanaugh said things like the severability analysis is quite, quote, straightforward, and it's, quote, fairly clear that the rest of the act would, in fact, be severable. After argument, when the Biden administration came in, the Solicitor General put in a letter, but not on standing, just on the merits and severability, saying, look, we disavow the position of the Trump administration. We got the decision, and as Sarah mentioned, this was a Justice Breyer special. It was 7-2 with a pretty broad majority, dismissing the case for lack of standing and not reaching any of the other issues. In terms of the standing holding, as you might expect, it's pretty fact-specific and narrow. Justice Breyer writes that individuals here can't show standing because the mandate is unenforceable. That's what zeroing out the tax penalty did. And if there's no real threat of enforcement under established Supreme Court precedent, there is no injury in fact traceable to the mandate. As for the states, Justice Breyer said two things. One is, to the extent they're trying to claim that the individual mandate increased their costs by causing people to join their Medicaid programs, the record just wasn't there. The states hadn't developed any showing that in fact people were signing up for otherwise beneficial state Medicaid programs just because of the individual mandate. So he said, look, you haven't made your record for injury on that theory. And to the extent you're relying on provisions other than the individual mandate, some other provision in the Affordable Care Act, well, that's not fairly traceable to the actual unlawful conduct. Because remember, the only provision alleged to be unconstitutional or unlawful in the suit was the individual mandate, not anything else. There was a one-third theory of standing, though, standing through inseverability, which is basically, hey, if I've been injured by one of the other provisions that's going to rise and fall with the individual mandate, that should be good enough to give me standing. And on that, the court said that argument was just waived. Only the Solicitor General raised that argument in front of the Supreme Court in their opening briefs. And because petitioners hadn't raised it, or because the states and the individuals, the challengers hadn't raised it, it was waived. So that's how they get rid of the case, 7-2. There is a dissent, Justice Alito, joined by Justice Gorsuch. And I guess I would describe that dissent as angry. Here's what Justice Alito says. He says, quote, "No one can fail to be impressed by the lengths to which the court has been willing to go to defend the Affordable Care Act against all threats. a penalty is a tax, referring to NFIB. The United States is a state, referring to King v. Burwell. And 18 states who bear costly burdens under the Affordable Care Act cannot even get a foot in the door to raise a constitutional challenge. So a tax that does not tax is allowed to stand and support one of the biggest government programs in our nation's history. Fans of judicial inventiveness will applaud once again. So it's clear where Justice Alito stands here. I think he's angry at the other, in particular at the other members, the more conservative members of the court who have, in his view, dodged what was yet another meritorious challenge to the Affordable Care Act. I will say, look, in terms of takeaways from this case, I think the whole point of this decision is to minimize the takeaways, narrow decision. What I will say is, even though Justice Alito invites a future challenge in his dissent, he says, look, this is just based on a record-based standing thing. Nothing prevents the states or others from suing again. I do think that the prospects seem dim. I'll never say never when it comes to the Affordable Care Act, but given the signals that Justice Kavanaugh and the Justice gave on severability, and given the majority opinion's language on standing, it seems very unlikely that any future suit would get traction in any meaningful way. So perhaps not, this will be the end of the major Affordable Care Act challenges. The second case that I'm going to talk about is the Alien Tort Statute case. This was Nestle v. Doe. This is the latest in a series of modern Supreme Court cases under the Alien Tort Statute, which is a 1789 law that provides U.S. federal court jurisdiction over suits by foreign citizens for violations of international law. It was originally used back in the day, and way back in the day, as a tool for assaults against foreign ambassadors, piracy, safe passage. It lay largely dormant for 2 centuries until the late 20th century, where it started to be deployed in a series of human rights litigation against foreign despots and multinational corporations. The Supreme Court steadily cut back on the reach of the Alien Tort Statute, but not close the door to Alien Tort Statute claims. I think 2013, there was the Kiabel decision, which basically said you can't rely on purely extraterritorial conduct to bring an ATS claim. And then there was Jesner terms ago in 2018, which says there can be no claims against a foreign corporation under the Alien Tort Statute. Now, in these suits, which come from the Ninth Circuit, they sued US corporations. This was a suit against US cocoa manufacturers alleging aiding and abetting of child slavery on Ivory Coast plantations. And basically the facts were that these US headquarters directed purchases from these plantations and provided logistical support and other training to these plantations, despite the knowledge that they were engaged in these horrific practices. There were 2 questions presented on which the court granted cert. First is, are suits against US corporations categorically excluded from the Alien Tort Statute? And 2, is the extent of what is the extent of US corporate aiding and abetting liability for otherwise extraterritorial conduct? I think the cert grant was an ominous sign for the plaintiffs who kept their suit alive in the Ninth Circuit, and the SG piled on. This was the Trump administration to support defendants in foreclosing all Alien Tort Statute liability against US corporations. And unlike in some of the other cases, like the Affordable Care Act and a few others, the SG did not lob in a letter changing its position in this case. And what you ended up getting was Justice Thomas writing for the court in somewhat of a mixed opinion, but the bottom line being 8-1, which is that this lawsuit could not go forward, so the defendants win, because it was based on primarily extraterritorial conduct. And what Justice Thomas writes in the holding joined by 8 members of the court, all but Justice Alito, nearly all of the conduct plaintiffs say aided and abetted forced labor, providing training, fertilizer, tools, and cash to overseas farms occurred in the Ivory Coast. And then Justice Thomas says, look, the allegations about general corporate decision-making happening in the United States, that's not enough to take it outside of the extraterritorial box. Justice Thomas wrote further, but he was only joined by Justices Gorsuch and Kavanaugh in writing that there should have been there should not have been a cause of action in the first place. That is, it's up to Congress. The ATS is basically a jurisdictional statute, and it's up to Congress if it wants to create cause of action beyond the 3 traditional violations of international law that existed back in 1979, piracy, assaults on ambassadors, and safe passage. Justice Sotomayor wrote separately to disagree, joined by Justices Breyer and Kagan, and disagreeing specifically on the notion that that only Congress could expand the torts recognized under the ATS beyond the 3 that existed at 1789. She says that works with the court's prior Sosa decision, which said it's not frozen in time, with Justice Gorsuch's separate opinion. And so now you have 4 justices, Sotomayor, Breyer, Kagan, and Gorsuch, that say you can, in fact, plaintiffs, you can sue U.S. corporations under the ATS. That gets you up to 4 on that end. And then you have Justice Alito's dissent, which, unlike his Affordable Care Act dissent, is sort of coming from the opposite end here. He provides a 5th vote on the notion that you can, in fact, sue U.S. corporation, sue any other natural person. So you have Alito and Gorsuch joining 3 liberals on rejecting that proposition from the defendants. And he would, rather than rule outright for dismissal, he would have remanded for further proceedings. Now, his reasons for remanding suggest that he ultimately nixed the suit. He said, look, there's a lot of these threshold questions, for example, the cause of action issue and other things that just haven't been aired in this case. Too much going on here. You should have just remanded it rather than dismissed. I think a couple takeaways from this suit. One is it wasn't the sweeping knockout victory that the business community had hoped for in getting a categorical bar on suits against U.S. corporations. In fact, as I mentioned, I think you can now count 5 justices for rejecting that argument. Yet, of course, the bottom line is this suit goes out. And so it's yet another instance, yet another hurdle of the series of hurdles that the Supreme Court has erected over time for bringing these sort of alien tort suits against corporate actors. So I'll pause there, Tom.
Thanks so much, Pratik. So what do you see as the future for ATS litigation? What is it? DOA? Are there real viable claims out there? Where this had become a bit of a cottage industry, and human rights advocates had been, viewed it as an opportunity. The statute is an opportunity, but do you think that's just a hollow hope?
Yeah, I mean, I think the window continues to narrow for these sorts of suits to actually have legs. You're going to need real allegations of active, not passive conduct by a U.S. actor overseas. And now we're talking about the claims against U.S. corporations. Claims against individuals, I think, will continue to go forward. The court has not laid down the sort of limits that you would have with respect to corporations. But when you're talking about suits against corporations, I really do think that the path, and it was already narrow, but has continued to narrow, that you are going to need real concrete allegations. This was all on a motion to dismiss. You're going to need concrete allegations that there was active conduct abroad that led to the abuses that you're challenging.
Okay. All right, so let's turn now to broader questions. And so I'd encourage folks to write questions into the Q&A box, and the ACS team will curate those for us. And please note your affiliation if you have any. And Lawrence Hurley has already asked one question that's, I think, really good for the group. And that is, look, take a step back. Tell us what it means to have a Justice Barrett on the court rather than a Justice Ginsburg. And I think you could think about that, somewhat narrowly in terms of just their own individual votes, but also more broadly about what it means to have a 6-justice majority rather than a 5-justice one. And I think with respect to each of your areas of the law, your thoughts are very welcome.
I'm happy to start, Tom.
Okay, go ahead.
You'd like.
Okay, great.
Yeah, sure. So look, I think there's no surprise. Look, Justice Barrett coming in has moved the court incrementally, but not to the right. You saw that, I guess, most concretely in the cases that Elizabeth was talking about, the COVID cases, where she was like the dispositive, that substitution made a dispositive difference in the outcomes. But I think more broadly, you saw the 6 justices that you would expect to be most in the majority, that is the 6 more conservative justices, were in the majority, and the 3 now, Justice Breyer, Kagan, and Sotomayor, were least often in the majority. I do think you saw some desire to create, if not consensus, at least less extreme rulings from folks like Justice Kavanaugh and Justice Barrett, which I think is completely understandable and not a surprise given the nature of those confirmation hearings. And I think combined with the Chief, Breyer, and Kagan, you saw some of those decisions that, as Elizabeth talked about in full, as you saw in some other cases, not going as far as they could have been going. But to me, the jury is still very much out on Justice Barrett. Is this just a short-term sort of, okay, look, there's no need to move quickly and dramatically and jeopardize the court's legitimacy and my own legacy when we're going to have this robust majority of 6 for years to come? And so to me, I think really the jury is very much out on how far, as I mentioned, it's going to move further to the right. The question is just how far and how quickly. And I think we'll get a taste of that next term with the guns and abortion cases, which I think will bring some of this to a head to, and shine a brighter light on the answers to those 2 questions.
I just wanted to, in the criminal law context, Justice Ginsburg was so-so, to be fair, honestly. You know, she, I would say, was moderate at best. And so I think it'll be interesting to see what happens going forward. And I think a lot of it is going to depend on, you know, Justice Scalia was kind of a wild card in some of the criminal cases, siding with the more liberal justices for some pretty big rulings on sentencing, confrontation clause, sometimes in the 4th Amendment realm. And so I'm just going to kind of stay tuned to see what happens with Justice Barrett in those areas. But, you know, it's actually possible that she could be Scalia-like in kind of going over to some of those. But it's, you know, also possible that, you know, she'll be more with the pro-government rulings. But the court overall has been very pro-government in criminal cases. You know, and that's true whether it's been a liberal or a conservative justice. You know, it's one of the reasons why I think it would be really valuable to appoint people to the Supreme Court who have some experience with criminal defense and civil liberties, and bring a perspective that's different from just being, you know, government side lawyering for a really long time. I think that would be you know, it's been a pretty depressing record for a pretty long time, and I see no reason to expect anything different.
Sarah?
I guess I have a little bit of a different view, maybe because I have a different view on the law, which is a good reason for a debate here. So I guess I'd say with respect to the term at large and sort of the idea of a somewhat uniform or durable 6-justice majority of conservatives, you can see that in a couple of cases, but I think less than you would expect for this term. And if anyone remembers the vote in Bostock, I think also a surprise in terms of people thinking conservatives will be in lockstep and not so much there. And I think this term also sort of proves it with one example, which is Justice Thomas voted with the liberal justices 3 times, which happens very, very infrequently, but also shows, I think, that some of the big cases, and those weren't like 2 of those were really, really big cases. Article 3 standing, where he voted with a position you would associate with people who are more pro-plaintiff. Obviously, his reasons weren't pro-plaintiff. And then in the separation of powers cases, in which he's siding with the liberals on some pretty big principles, but you know, in meaningful sense. So I'm not sure that sort of the having 6 conservative justices necessarily translates into uniformly sort of conservative outcomes, especially given how fragmented they've been. The second sort of observation just about Justice Barrett specifically, I mean, I personally thought she brought her A game to both her opinion writing and argument, and I think the court is in some way like having fun with that. I mean, I really look forward to in-person argument because I think she's going to be sort of maybe perhaps Justice Scalia's air in that sense of being a very probing questioner. I think she's very polite, so I think that'll be nice. But I think she has made an impact. She's written a couple of dissents that got joins from various liberal justices, I think because her reasoning was very compelling. So the Penn East dissent in a sort of eminent domain state sovereign immunity case is one example of that, getting Justice Kagan's vote. And then third, I do think, I mean, she obviously was outcome determinative in 2 cases, Arthrex, one of the separation of powers cases, and TransUnion, a really, really important case about Article 3 standing. So she's already, I think, made an impact there. I think Justice Ginsburg may well have voted the other way in those cases. And then just one more thing in response to something Rachel said, which is, I actually think in the criminal justice space, the interesting move has been Justice Thomas sort of leading the way on rethinking qualified immunity from the right. Obviously, I think the justices on the left are also very skeptical of qualified immunity. So the interesting question is there close to 5 now? And what will Justice Barrett do in that space? Because I conceivably count Justices Thomas, perhaps Justice Gorsuch, and then some combination of liberals. So is Justice Gorsuch the 5th? Is Justice Barrett the 5th? I don't know, but I think that the court actually might cut back on qualified immunity going forward on a completely non-ideological lineup.
Although they did recently decline to take a case, right? Which means they didn't have 4 to do it last term.
Yeah, well, I think the some revs may explain why they didn't do it just yet, but unusual term for some reversals in which the court is saying actually you should not have extended qualified immunity.
So let's turn maybe to Elizabeth's point earlier of, what do we think of the court's more liberal justices? Sometimes you have stark 6-3 decisions, and we did today. But in some areas, you see what seem to be rough-hewn compromises in which they're trying to slow down the development in the law and the movement of the law to the right. And the question I have is, what is that a distinct strategy? Are there times where they are bending right in order to get the chief and Justice Kavanaugh and Justice Barrett perhaps to move a little more slowly, playing the long game? Or, do we have actually a much more conservative court across the board than?
Tommy, I think both things can be true, because it kind of comes back to Pratik's point about what the rate will be. It is by any measure, it's a very conservative court. By any measure, it's the most conservative court in recent memory. Many years ago, Justice Stevens said that every justice that succeeded a retiring or deceased justice was more conservative than the predecessor. Justice Stevens said that very, very late in his service, and it's just become a more pronounced version of that. So by any measure, it's a conservative court. When we are asking whether or not Justice Roberts is the middle of the court, an idea that would have been absurd to many folks a few years ago. It's another measure of how conservative the court is. But the court is an institution. It's an institution that has to think about its legitimacy and credibility in a very fractured political environment and in a very fractured nation. With respect to the democracy cases, hearkening back to the cases of which I spoke, at the time of Shelby County, we were some folks were wondering, or at least considering, whether or not we were past some of the bad old days of racial discrimination in voting. Situation where contestation about voting, about the underpinnings of democracy itself, threatened the House of Government and the seat of congressional power with the flying Confederate flag, and with the president himself trying to overturn an electoral outcome. So there are threats that are real and in evidence that the court has to take account of in terms of how it advances its vision of the law and its interpretation. And so in some cases, they will swing for the fences and make big steps. In other cases, with the security of that 6-judge majority, it may be prudent to take it in smaller bites. But I don't think that we should get confused about whether or not this is a very conservative court. By any historical measure, it is.
Yeah, and on the strategy part, I think it's a really interesting question. We've had a couple criminal law cases the past couple terms that involved greater protections for defendants, but you'd have to overrule some precedent. Ramos being one example of that, involving unanimous juries. And, I don't want to say it was a purely strategic decision, but, there may have been some hints that Justice Kagan was thinking, I'm not going to overrule this here because I want to maintain my credibility when the big ticket abortion cases come up to say how much I respect precedent. And so I do think there's a little bit of thought of kind of which cases am I willing to sacrifice for a kind of longer term credibility. And honestly, I don't know what the right answer is to something like that. I have a belief after reading cases like the ones I read this term, like Jones versus Mississippi, that it doesn't much matter. I don't know that having staked out a principled position on stare decisis in a case like Ramos is going to slow down the train that's coming to overrule cases in the future. So, I tend to think that may be, if had it been a strategic decision, I don't know that it's going to bear fruit. And I'm not sure it's worthwhile going forward in other areas to kind of keep holding out that hope, because I think this court picks and chooses which cases and precedents it sticks to, which ones it kind of overrules by stealth, and which ones it does explicitly without really any consistent playbook or set of principles. And so I'm not sure that if the more liberal justices are the ones trying to slow things down by showing principle, I'm not sure that each side is playing by the same rules and that it matters.
Well, let's use that as a jumping off point with 5 minutes left to talk about the future. Pratik has mentioned the upcoming abortion decision and gun decision. We've mentioned the prospect of Justice Breyer's retirement, at least in the medium term. What are you all looking at over the course of the next 12 months or so as the most significant things to watch? Elizabeth?
I mean, I think Dobbs, the abortion case, is incredibly significant, especially for those of us in the South or in states that have trigger laws or the like, are trying to ban abortion pre-viability. So I really think that that's an important case, and it's hard to see how you don't get to 5 or at least 6, given the decision to take up Dobbs. There's lots and lots of religious objection cases, and ones that are probably cleaner than Fulton, which involve government contracts. So watching those 2 more on the public accommodations, wedding vendor side, and in the healthcare space. So that's what I'm watching to see what the court does with those.
Pratik?
Yeah, so I would definitely agree with that. I mean, here's the way I think about it as we look ahead in the next 12 months, 24 months, the next coming terms, plural, is look, we went and this is just in my lifetime as a practitioner before the court. Obviously, you can go back further, but the median justice in the court went from Justice O'Connor to Justice Kennedy to the Chief Justice last term to Justice Kavanaugh this term, was the justice most often in the majority. That is a dramatic shift. If Justice Kavanaugh is your median justice, nobody would contend that is truly a moderate justice, right? I mean, this is not you have to have a very skewed baseline in order to consider that a moderate middle. And that's where we've gotten, right? That's how the press is talking about it, how the commentary is, oh, this term is surprising, we're seeing moderate lineups and all that. To me, that's not the right way to think about it. You have to look at it in the context, and you see the progression to the middle. So to me, when you have the abortion and the guns cases and these other cases coming up, the question is, where is Justice Kavanaugh going to land? It now no longer matters where the chief lands, even if he wants to join the liberals. The question is, where is Justice Kavanaugh and maybe Justice Barrett on certain issues? We don't have enough data points yet, but where do they land? How far and how quickly do Justice Barrett and Justice Kavanaugh want to go? We know that the other 3 on the right may not care as much about the perceptions of the court, but I think Justice Barrett and Justice Kavanaugh do. And so to me, that's who I'm watching, particularly in these 2 big cases next term, but even more broadly. I think the one area where you might not see that dichotomy or that view kind of flesh out is business cases. I think are a little bit trickier because the court has pushed so far right in some areas like arbitration and those sort of things where, I think we'll see some of the funnier lineups that you've seen so far, and it may not mesh. Criminal law has obviously been different for the reasons that Rachel talked about, with Justice Gorsuch kind of, I think, embodying the Scalia maverick streak and that sort of thing. But in essence, to me, that's what to watch: Justice Kavanaugh and Justice Barrett.
Sarah, can you finish us off?
I mean, I guess I do view it differently because I think that it's a court of mavericks among the conservatives. And so if you look at the median justice sort of overall, I'm not sure it's the right metric. There's a lot of cases in which Justice Gorsuch sort of breaks and flips with the liberals in criminal cases. There's a lot of cases in which Justice Thomas does that. And you can pick, I think the liberals have actually outpunched their weight in terms of potentially driving strategy and picking off votes. Now, does that produce results that I think politically are popular among liberals? Like, probably not. But does it produce sort of opinions that don't do a lot or reach a result that seems to reflect the actual consensus of the justices? Yeah, and I think that actually does explain a lot of this term. So what am I looking for? I mean, actually something totally different, which is, will the court ever get back up to its regular numbers? And is its docket going to be driven for the next 4 years by like nationwide injunctions the way it was for the past 4 years? I think right now we're kind of in a lull period for administrative law challenges to the new administration. I think they're going to pick up as rulemaking happens. And I think that's going to be just an enormous driver of the court's docket potentially, because I do think the trend in the last couple of years has been, if there are single courts that enjoin a nationwide policy, the court does seem like it feels like it's compelled to intervene. It's a big policy and it's enjoined nationwide. And so if that continues to happen, I think it's going to tee up both a lot of big challenges to the Biden administration's policies and also questions about our nationwide injunctions a thing.
All right, well, thanks so much. Thanks to ACS and to Senator Feingold and to all of the panelists and to the hundreds and hundreds of people who watched on Zoom and then through the ACS website and who will watch it recorded. We look forward to getting together with you in the new term. Thanks.